They thought I was losing my mind, and for a while I almost believed them. My name is not important. What matters is that I spent 41 years building something, a small electrical contracting business in Barrie, Ontario, the kind that starts with one van and a phone number painted on the side and ends, if you're lucky and stubborn enough, with 12 employees and a reputation that means people call you back. I built it. My hands, my license, my risk. When I sold it in 2019, 2 years after my wife passed from ovarian cancer, I walked away with just over $2.3 million. I put most of it in registered accounts, RRSPs, TFSAs, and parked the rest in a non-registered investment portfolio with a fee-only advisor named Sandra who worked out of a small office on Dunlop Street and charged me a flat annual fee instead of commissions. I like that. No hidden incentives. She made money whether my money grew or not, so she had no reason to lie to me. I was 63 when all of this started. I was healthy. I walked 4 kilometers every morning along Kempenfelt Bay regardless of the weather, because my doctor told me to, and because the cold air helped me think. I had a bad left knee from an old fall off a ladder in 1998, and sometimes I forgot where I'd put my reading glasses. But I was not, by any reasonable measure, a man in decline. My son, he's 37 now, had always been the kind of person who made things look like your idea. Even as a teenager, he had this way of steering a conversation so gently you never noticed the steering. I used to think that was a gift. I used to be proud of it. He went into finance, got his CFA designation, married a woman who worked in real estate law. They had 2 kids. I loved very much and saw every few weeks when they came up from Vaughan for Sunday dinners. It was my daughter-in-law who planted the first seed, though I didn't know it then. It was a Saturday in late February, one of those flat gray Ontario days where the snow has turned to crust and everything smells like salt and exhaust. She was standing in my kitchen watching me make coffee, and she said very gently, very carefully, "You know, you left the stove on again last Tuesday." I hadn't left the stove on. I remembered exactly. I'd made soup, turned off the burner, wiped down the counter, then walked to the living room to watch the news. But she said it with such quiet concern, such careful eyes that I second-guessed myself for a moment. Just a moment. And that moment was enough. Over the following months, it became a pattern. Small things. The car keys I'd supposedly left in the door, though I had a habit of putting them on the hook by the garage, always for 30 years. The phone call I'd allegedly missed, the appointment I'd forgotten though I had it written in my paper calendar. Each incident was small. Each was gently, lovingly noted. By my son, by my daughter-in-law, sometimes together, sometimes in separate conversations as if they hadn't coordinated, though I later learned they had. It was my friend Ted who noticed before I did. Ted Larkin, retired teacher. We'd played hockey together in a men's league for 22 years before our knees gave out. We had coffee every Thursday at a place on Bayfield Street, and one Thursday in October, he set down his mug and looked at me and said, "Frank." That was what he called me, though it wasn't my name. It was an old joke going back decades. The kind of nickname that only makes sense inside a friendship. He said, "Something is off with those two. You've mentioned 4 different things in the last 2 months that don't add up. What exactly are they saying to you?" I told him, everything, the stove, the keys, the appointments, and a newer one, my son had suggested, with tremendous warmth and apparent love, that we think about setting up a power of attorney. For my protection, he said, just in case. Because he loved me and wanted to make sure I was taken care of. He'd even brought a form. Ted was quiet for a long moment. Then he said, "Don't sign anything." I didn't. Instead, I went home and did something I hadn't done in years. I sat at my desk and went through every financial statement I'd received in the past 12 months. Sandra sent me quarterly summaries, and I had every one in a binder. I cross-referenced them with my own notes. I kept a small notebook, a habit from the trade, where I logged anything that cost money or moved money. Everything matched. My accounts were intact. Nothing had been touched. But that was when it was still early. My son called the following week. He was measured, professional, the way he got when he prepared what he wanted to say. He told me he'd spoken with someone, a geriatric care specialist, and that he thought it might be worth having me assessed, not as a criticism. Out of love, he used the phrase, peace of mind, 3 times. He said he'd already made an inquiry with a clinic in Toronto. I said I'd think about it. Then I called the lawyer. Her name was Patricia Osei. She worked out of an office in Barrie, and she came recommended by my accountant, who was the one person in my life I trusted completely and had not mentioned any of this to until that week. Mrs. Osei was 50-something, quiet, precise, and she listened without interrupting for 22 minutes while I laid out everything I remembered. When I finished, she looked at me and said, "Have you been assessed by your own physician recently?" I had. Standard annual physical in August. My GP had given me a cognitive screening, part of the routine for patients over 60, and I'd scored normally. I had the printed summary. "Good," she said. "Keep that, and let me tell you what I think is happening." She walked me through it. She'd seen versions of it before, not always this calculated, but the shape was familiar. A vulnerable adult, real or perceived cognitive decline, the gradual introduction of a personal directive or power of attorney, and then control of assets. She told me that in Ontario, if a person is deemed incapable and a family member is granted power of attorney for property, they can have extraordinary access. She told me to be very careful about what I signed. She told me to document everything going forward. I drove home and bought a small digital audio recorder from a shop on Essa Road, the kind journalists use. Fits in a shirt pocket. I also went through my house and found, tucked behind the thermostat in the hallway, something I hadn't put there, a small device I didn't recognize. I photographed it, showed it to my neighbor's son who worked in IT. He told me it was a basic Wi-Fi camera. Someone had been watching my living room. I left it where it was. I want to say I was angry. I was. But underneath the anger was something quieter and colder, a kind of grief. Because this was my son. This was the boy I'd driven to hockey practice at 5:30 in the morning for 6 years. The one I'd co-signed a loan for when he was 24 and just starting out. The one I'd sat beside in the hospital when his first child was born, crying in the corridor because I was so full of something I couldn't name. I kept looking for the version of him that made this impossible, and I couldn't find it. I met with Ms. Impossible, and I couldn't find it. Oh, say, 3 more times over the following 2 months. I gave her a copy of my complete financial records. I had Sandra prepare a formal asset summary, signed and dated, showing the state of my portfolio. I retrieved my most recent cognitive screening from my GP, and I brought her the photograph of the camera device. She also connected me with a colleague, an investigator named Derek Bowman, who did financial background work for law firms. Within 3 weeks, he had found something. My son had consulted in writing with a wealth management firm in Toronto about the process for assuming control of a parent's RRSP funds in cases of established incapacity. The email trail, obtained through legal means I won't detail here, made it clear that this had been discussed before any concern about my cognitive health had ever been raised with me, before the stove incident, before the keys, before any of it. They had planned this before they had a reason. I said nothing. I kept having Sunday dinners. I kept taking my morning walks. I kept answering my son's calls and listening to his careful questions about how I was feeling, how I was sleeping, whether I was keeping up with things around the house. I said I was fine. I said I felt a little tired sometimes, but that was normal. I made it easy for him to believe what he wanted to believe. In January, my son told me he'd moved forward with a formal application. He and his wife had applied under Ontario's Substitute Decisions Act to have me assessed by an independent evaluator for the purpose of establishing a guardian of property. He presented this to me on a Sunday afternoon in my own kitchen, with his wife beside him and a folder of documents on the table, and he told me it was for my own good. His wife said they'd been so worried. She reached across the table and put her hand on mine, and I looked at her hand and I thought about that camera behind the thermostat, and I kept my face still. I told them I understood. I told them I understood. I told them I wasn't angry. I told them I just needed a few days to process it. That evening I called Ms. Osei and told her it was time. The assessment was scheduled for mid-February, a Thursday, at a clinic in Bari. My son had arranged it. What he did not know was that I had already been independently assessed by a neuropsychologist at Royal Victoria Regional Health Centre, a full cognitive battery, not a screening, 6 weeks earlier. The results were on file with Ms. Osei. They showed no evidence of cognitive impairment of any kind. The neuropsychologist, Dr. Amara Nkosi, had written in her summary that I performed in the above-average range for my age group on all measures of executive function, memory, and processing speed. My son and daughter-in-law attended the scheduled assessment clinic. I did not. Instead, my lawyer filed a responding application with the Ontario Superior Court of Justice, along with Dr. Curate. Nkosi's report, the financial records, the photograph of the surveillance device, and the documented email trail from my son's consultations with the Toronto wealth management firm. The hearing was set for March, a Tuesday, downtown Barrie. I wore a suit. I want to be specific about this because it matters in a way that sounds small but isn't. I wore the charcoal suit I'd bought for my wife's funeral and had dry cleaned and hung in the closet ever since. I shined my own shoes the night before, the way my father taught me, with a soft cloth and 2 coats of polish. I wasn't going in there looking like a man who needed to be taken care of. I was going in there looking like myself. My son and daughter-in-law were already in the courtroom when I arrived. They were sitting with their lawyer, a younger man I didn't recognize, and they were talking quietly, leaning close, and my son looked confident, almost relaxed. He'd done his preparation. He had the assessment clinic records and a family doctor's referral letter and a list of witnesses who would speak to observed incidents of confusion. He had what he thought was a case. He hadn't expected me to have a lawyer. When Ms. Osei walked in and sat beside me, I watched my son's expression shift. Something moved behind his eyes. He looked at me, and I looked back at him, and I held his gaze, and I didn't look away first. His wife leaned over and whispered something to him. He shook his head slightly. The presiding judge was a woman named Justice Calloway. She was methodical. She reviewed both applications without expression, asked several clarifying questions of both counsel, and then asked that Dr. Nkosi's full report be entered into the record and read aloud in summary. The court clerk read it. When the clerk reached the section on executive function and the conclusion that I showed no indicators of cognitive impairment, I heard my daughter-in-law make a small sound, a breath. The kind that means a calculation has just gone wrong. Then Justice Calloway asked my son's lawyer to explain the basis for the application given the neuropsychological findings. His lawyer stumbled. He'd clearly not expected this document. He asked for a recess. The judge allowed 15 minutes. During that recess, my son walked across the room to where I was sitting. He didn't look confident anymore. He looked smaller than I remembered, or maybe I was just seeing him more clearly. He said quietly that we didn't need to do this, that we could work it out, that he was sorry if he'd worried me. I said, "You had a camera in my house." He didn't answer. Ms. Osei had filed a secondary matter alongside the Guardian application response, a complaint to the Ontario Securities Commission regarding the unauthorized consultations about my registered accounts. given that I had not consented and had not been declared incapable at the time those consultations occurred. She had also flagged the surveillance device to the Barrie Police Service as a potential criminal harassment matter under the Criminal Code of Canada. When we returned to the courtroom, Justice Calloway dismissed my son's application with full written reasons. She found that the evidence presented did not meet the threshold for establishing incapacity, and noted, in measured but clear language, that the timeline of the consultations with the wealth management firm raised serious concerns about the applicant's motivations. She ordered that costs be awarded against my son. He was required to pay a portion of my legal fees. Outside the courthouse, my son and his wife left quickly. They didn't speak to me. Their lawyer walked out behind them looking at his phone. Ted was waiting for me on the steps. He'd driven down from his place on the north end of the city and was standing there in his old blue parka with 2 coffees from the Tim Hortons on Dunlop Street. He handed me one, and we stood there for a while in the cold March air, not saying very much, because there wasn't much that needed saying. The OSC matter took another 4 months to resolve. In the end, the wealth management firm received a formal regulatory warning and was required to revise their intake procedures for cases involving third-party family members. My son was not charged criminally. The police reviewed the surveillance device matter and determined that the circumstances, while troubling, did not meet the threshold for a criminal code charge under the current provisions. I was told that if the camera had captured audio without consent, it would have been a different outcome. It captured video only. I cannot tell you the investigation didn't hurt. It did. Every piece of paper, every meeting, every time I had to narrate what my own son had done, it was its own kind of loss. I don't think I will ever fully understand what happened to him. Whether it was her influence or financial pressure I didn't know about, or something in him that I simply missed in all those years of Sunday dinners and hockey practices and conversations I thought were honest. I have thought about it more times than I can count. What I know is this: I was not confused. I was not declining. I was not someone who needed to be managed. I was a man who built something over a lifetime with his own hands, who loved his family more than he was wise to, and who was, in the end, paying attention. I still walk along Kempenfelt Bay every morning. The knee is worse than it was. I go slower now. But I go, and my accounts are still mine.